Are you a bachelor or a spinster, or you're a divorcee, you're a widow or a widower, and you plan to get married? You want to marry under the act, or what we call court marriage. You don't know the procedure, you don't know how to go about doing that, or you are married and you have children, you want to register it, you want to have a court marriage. How can you go about that? What will you do? What are the procedures? What are the consequences for somebody to lie and get married under the act? This and so many more we'll be discussing in the next part of this video. Follow me as we go into the next level to discuss this issue. Click on the subscribe button, like this video, or drop your questions or comments in the comment section as we discuss the marriage under the act. Thank you. Welcome back. My name is AI Ango. I'm a legal practitioner, a notary public, and a chartered arbitrator. Today we'll be discussing marriage under the act, which we know very well to be court marriage. It is marriage under the act. We'll be looking at who can marry under the act, what is the age that somebody will be married or can be said to be married under the act, what are the procedures, what are the penalty and the consequences for anybody that lied about getting married under the act. First and foremost, let's look at who can get married under the act. Anybody that is within the age bracket of 21 and above can apply to the marriage registry to be married under the act. For example, where the couple are 21 years and above, they can confidently apply to be married under the act. But when the person is below the age of 21, for that person to be married under the act, that person must come with the consent from either the father. If the father is not alive or is not in the country, then the mother will give the consent. If the mother is not alive or she's not in the country, then a guardian can give the consent with an affidavit that he is allowed to do so. So if anybody is below the age of 21, he or she must come with a consent from the parents or the guardian that they allow the person to be married under the act. Other than that, that marriage will not hold. So first, you must be within the age bracket of 21 and above to be married under the act. How do you go about that? You will apply to the marriage registry, to the registrar at the marriage registry, that you intend to get married. And the registrar will now put your name and a notice on the public notice board that so person and so person are planning to get married at so dates. Now that notice must be there for 21 days. 21 days. So that if there's anybody having any caveat or anybody having any reason why that marriage shouldn't hold, that person will go to the registry and there's a book open where the person will go and write forbidden under the name of the persons intended to get married. Meaning it's a caveat. Meaning that these persons are not allowed to get married. There's a reason for them not to be married. Then after, if there is a reason for them not to be married, then the registrar now will take the comment made to the High Court, where the High Court judge will call the parties, the ones that are about to get married or planning to get married, and the one that came and wrote forbidden, to hear from their side why is that person intending to stop this marriage. If there's a good reason, then the marriage will be cancelled. If there's no good reason, then the High Court judge will cancel the forbidden and permit that wedding, sign his name and permit that the wedding should go on. And if there's no cogent reason, the High Court can still penalize that person that came and wrote forbidden for not giving a cogent reason. But so if you are going to give any reason for a wedding not to be held, you must be sure you have a very cogent reason. Otherwise, don't even try it. Now, if after 21 days, there is nobody that came up with any reason to stop that wedding, then the registrar of the marriage registry will give a date that wedding will be conducted. Now, the wedding must be conducted within 3 months from the date of the registration of that public notice. So it must be conducted within 3 months. If it is more than 3 months, the process must be started all over again. So you must plan your wedding to be within that space of 3 months from the day you are going to meet the registrar to notify him of your planning to get married under the act. Now, once that thing is done, then the next thing is the place of celebration of the marriage. The place of celebration of the marriage or the wedding must either be in the marriage registry or any public place of worship, a registered public place of worship. It could be a church if it is registered, or a mosque if it is registered, so that at the end of the marriage, the imam or the pastor will issue out the certificates, that is the court certificate as well as the church or mosque certificate, to the couple. That place of worship must be registered. So an unregistered place, a wedding cannot be held in that place. So it must be a registered place of worship, and the marriage must be between the hours of 8 o'clock in the morning to 6 p.m. in the evening. It cannot be before 8, or it cannot be after 6 p.m. No, it must be between 8 a.m. in the morning to 6 p.m. in the evening. That is when the wedding can be conducted, and it must be in an open place, not that the doors and windows are closed. No, it must be an open place where anybody can have access to. Now, if that is done, then we move on to the next step. What is needed from somebody who applied to the registry that he wants to get married? You must have an affidavit to show that you don't have close affinity tie with your spouse. There's a close affinity tie. When we say affinity, we mean relationship, blood relationship. For example, a brother cannot come to say he's marrying his sister, or a son marrying his mother. These are affinity ties that the law prohibits that you can't marry. So you must post to an affidavit that you don't have this close affinity tie with your spouse. And you must also clearly tell the court or explain in the affidavit that you are not married before this one that you're going to do. That is, you are not legally married to anybody. That is to say, you are single. You are not attached to anybody. These are things, these are facts you must depose to in an affidavit. And also, you must reside in that state where you want that marriage to be conducted for 15 days. 15 days, unbroken 15 days, you must have resided. One of the spouses must have been in that state for 15 days. Minimum of 15 days, you must have resided in that state. So when you have deposited that affidavit, these are things you will attach to and then submit to the registrar, and the registrar now will enter you into the marriage register, and a date will be given and the wedding will be conducted. Mark you, when you lie about certain things in your affidavit and you are found guilty of that, you will be convicted and sentenced to 5 years imprisonment. You lie about your age, or you lie about your name, or you lied about your marital status. If you are found, you will be sent to prison for 5 years. You must understand that you cannot be married under your custom and tradition and is still subsisting, and then come to marry under the Marriage Act. It is not permissible. It's not permissible. Or you cannot be married under the act and then now again you go back to marry another person. That wedding is null and void. For those of our sisters and our brothers that you already married under the act and you go and meet somebody and promise that person you want to marry that person. You that you are promised married, I'm telling you, you are only being deceived, because that marriage will never stand. If a person is already married under the act, he cannot marry another person again, except he divorces that person or that person dies. That is the only way that he can marry. And if a person is coming to marry under the act and he or she stated that she is or he is divorced, then he must or she must produce a divorce certificate. It is very essential. And if a person claims that he or she is a widow or widower and is coming to marry under the act, then he must produce or she must produce a death certificate of the spouse that he or she claimed to have died. Other than that, the marriage under the act will not recognize that marriage. So, you are a bachelor, you are a spinster, and somebody promised to marry you. Already that person is married under the act, and you foolishly agree to marry that person. I am telling you, the truth is, you are nothing other than a side chick, if I may use that word, or a side cock, because that marriage is not recognized, is null and void. Peradventure, that person passes on, you stand to get nothing as a wife or as a husband, because that marriage is not recognized. Even if you have children for the man, you still cannot benefit anything as a wife, because you are not recognized as a wife. You are only a side chick. It is only the children, if you have children with that person, that can benefit, but you cannot benefit anything as a wife, because you are not a wife in the first place. So the Lord did not even recognize you. You only gave birth to children with him, so you stand to lose, except if the man made a will and included you as part of the beneficiaries as ordinary somebody, but not as a wife. So you just benefit as normal person, but not a wife, if he left a will. But without a will, you cannot benefit anything from his property as a wife. So you need to be guided. You need to understand that marriage under the act, especially for those that have done it, it is protecting the family, protecting you, protecting the sanctity of marriage. That is, it is meant to be one man, one woman. That is married under the act. You may ask now that I have been married. I married my spouse in the customary or traditional way, or in the church, and we do not have this church certificate. We only have the church certificate and not the court certificate. How do I go about that? Very simple. If you're already married and you have children, or you don't have children but you've been married but not under the act, you can regularize that. You can go to any marriage registry and apply to the registrar of the registry that this is what has happened. You are already married, or you want to register your marriage. The marriage registrar at the registry will take your details and then register you and issue to you a certificate of the court to show that you are now married, or your marriage is now recognized by law. There are so many advantages you stand to gain when you are married under the act. For example, you want to travel abroad, you are going for your NYC service, you are saying you are married, but they are saying, okay, produce your certificate. You want to bring your church certificate or your mosque certificate or your traditional certificate. They'll just look at you and say, no, this is not what we recognize. We need that of the court. So you already have it, you just tender it. It is recognized anywhere in the world. Once you are married under the act, you are recognized as a married couple anywhere in the world without any problem. So you stand to gain a lot. If you are married already and you have not registered your marriage, it's not late. You can go and register. Or if you are about getting married, it is not bad. You can plan towards that, get your lawyer, and then he will guide you direct. So don't just get mad. Get a lawyer, and he will lead you and he will guide you. Thank you for watching this video. Click on the subscribe button, like this video, drop your comments at the comment section, and we will appreciate and respond to you appropriately. Thank you.